Chapter 3. Axiomatic Truths About Women. The female lawyers who came before proved the difficulty of defying cultural expectations. Indeed, the qualities in a successful lawyer, the ability to think rationally and analytically, the ability to engage in public speaking, possession of a certain toughness, and the ability to occupy a position of authority as an officer of the court, ran directly contrary to the common view that women were fragile, emotional, and hence unsuited for public life. The women who came before showed something else as well. Those who had the gumption, the stamina, and the intelligence to work around barriers often found themselves in a position of much greater significance than if the barriers hadn't been there in the first place. Myra Bradwell was born Myra Colby in 1831. As was typical of upper-class girls in the middle part of the 19th century, Myra attended a finishing school intended to train girls for their future roles as wives and mothers, and offer a broad education in literature and the arts. After finishing her education, Myra taught at the seminary for a year. While teaching, she met James Bradwell, who came from a family of poor English immigrants and was financing his education by doing manual labor. Myra's family had no intention of allowing her to marry a manual laborer, so Myra and James eloped. Myra's brother pursued them with a shotgun, but was unable to stop them. They were married in Chicago on May 18, 1852. Myra's inclination to rebel didn't stop with a runaway marriage. After James completed his education in 1855 and was admitted to the Illinois bar, Myra decided she wanted to work with him in his law practice. There were two ways to become a lawyer: attend a law school or study law under the supervision of a practicing lawyer. As a woman, Myra wasn't permitted to attend law school, so she studied with James. She was 38 years old when she passed the Illinois bar exam with high honors and became the first woman in the United States to apply for a license to practice law. She submitted her application the usual way, accompanied by a court certificate attesting to her good character and the results of her examination showing that she possessed the requisite qualifications. The Illinois Supreme Court denied her request on the grounds that the law that applied to her as a married woman would prevent her from practicing law. Under the law in Illinois, as derived from common law, a woman had no legal existence apart from her husband. By marriage, the husband and wife are one person in law. That is, the very being or legal existence of the woman is suspended during the marriage, or at least is incorporated and consolidated into that of the husband, under whose wing, protection, and cover she performs everything. A married woman could not own property in her own name, enter into contracts, sit on juries, vote, run for office, or even apply for credit without her husband's permission. Limitations that, according to the Illinois Supreme Court, would interfere with Myra's ability to practice law. How, for example, could she freely enter legal agreements with her clients if she needed her husband's permission each time she wanted to enter a contract? Myra challenged the decision. She admitted she was married, but insisted that she nonetheless had the right as an American citizen to practice law. The Illinois Supreme Court issued its final response, relying on the fallback position that the Illinois legislature did not intend women to practice law, so the court had no authority to grant a license to a woman. The court concluded that even if not forbidden to do so by law, it would deny her application because God designed the sexes to occupy different spheres of action, and that it belonged to men to make, apply, and execute the laws was regarded as an almost axiomatic truth. Myra brought her case to the United States Supreme Court. She invoked the newly ratified 14th Amendment of the United States Constitution, which guaranteed all persons equal protections of the laws. Her argument was a simple one. The 14th Amendment of the Constitution plainly decreed that no state may deny any person equal protections of the laws. She was a person. The Illinois law deprived her of equal protection. Therefore, the Illinois law violated the Constitution and must be overturned. She must have known she was on shaky ground. The 13th, 14th, and 15th Amendments, known collectively as the Reconstruction Amendments, were ratified immediately after the Civil War to give the newly freed slaves the full rights of citizenship. Indeed, the Supreme Court ruled against her, holding that the 14th Amendment didn't apply because the intent of the Reconstruction Amendments had nothing to do with whether women could practice law. Justice Bradley's concurring opinion echoed the sentiments of the Illinois Supreme Court by describing the different spheres and destinies of men and women. Man is, or should be, woman's protector and defender. The natural and proper timidity and delicacy which belongs to the female sex evidently unfits it for many of the occupations of civil life. The Constitution of the Family Organization, which is founded on the divine ordinance as well as in the nature of things, indicates the domestic sphere as that which properly belongs to the domain and functions of womanhood. The harmony, not to say identity of interests and views which belong or should belong to the family institution, is repugnant to the idea of woman adopting a distinct, independent career from that of her husband. And there's Justice Bradley's oft-quoted conclusion, which goes like this: "The paramount destiny and mission of woman are to fulfill the noble and benign offices of wife and mother. This is the law of the Creator, and the rules of civil society must be adapted to the general constitution of things and cannot be based on exceptional cases." Even after being told by the United States Supreme Court that women were not included as persons under the 14th Amendment, women refused to give up. One woman after another read the Constitution, saw the word person, believed she should be included, and tried unsuccessfully to argue in court that even if the original framers hadn't intended to include women, it was time for that to change. In 1872, when Virginia Minor tried to register to vote in the upcoming presidential election, the St. Louis District Registrar, Reese Happersett, refused to allow her to register because she was a woman. She wanted to sue, but she couldn't without her husband's permission. Her husband gave permission, so she sued on the grounds that the 14th Amendment guaranteed equal protection of the laws to all persons, and she was a person, therefore she should be allowed to vote. Her case went all the way to the United States Supreme Court. The court ruled against her, holding that while women were citizens and persons, and as such owed allegiance to the United States, so were children, and nobody would expect a child to be given the right to vote. Meanwhile, Myra Bradwell, denied the right to practice law, established the Chicago Legal News, which became one of the most influential and widely read law journals in the Midwest. In a column called Law Relating to Women, she argued for legal and political equality for women. Her paper provided support for women trying to obtain law licenses in their own states. She became active in the suffrage movement, joining with other suffragists to form the American Woman Suffrage Association in Cleveland. That same year, Elizabeth Cady Stanton and Susan B. Anthony founded the National Women's Suffrage Movement. In 1890, the two groups merged to become the National American Suffrage Association. That same year, the Illinois Supreme Court, acting on its own motion, granted Myra a license to practice law. She lived to see her efforts come to fruition when women were granted the right to vote in 1920 with the ratification of the 19th Amendment. Colonial men might have believed that women were unfit for such professions as the practice of law, but when the country was undeveloped and sparsely populated, and when there weren't enough men to do the work, it often happened that the most capable person, and sometimes the only capable person, was a woman. Margaret Brent, born in 1601, known to her contemporaries as Mistress Margaret Brent, spinster, was America's first woman lawyer. In a loose sense of the word, of course, because there wasn't yet a United States of America, and what could be termed the legal profession was unregulated and unlicensed. Margaret was born in Gloucestershire, England, into a well-to-do Catholic family, members of the landed gentry. In 1638, at the age of 37, Margaret, an unmarried woman, came with two of her brothers and her sister, also unmarried, to the colony of Maryland in search of religious freedom. Margaret, it turned out, had a head for business. Because she was single, she was allowed to own property. She went into the tobacco business with a grant of land from the governor of Maryland, Leonard Calvert, and by hiring indentured servants. She often appeared in court to collect debts and manage her business affairs. Governor Calvert came to trust her, and on his deathbed he appointed her as his executrix, which put her in the unusual position of managing state affairs and finances. After Governor Calvert's death, his brother, Lord Baltimore, then residing in England, inherited Maryland and became governor. Margaret paid Governor Calvert's debts, as he requested, and discovered that there wasn't enough money to pay the soldiers he'd hired to protect the colony. The soldiers were angry and threatened mutiny if they weren't paid. Margaret therefore went to the provincial court and asked that she be named the absent Lord Baltimore's attorney. Her request was granted. She used her power as Lord Baltimore's attorney to sell some of his cattle to get the money to pay the soldiers, thus preventing a rebellion. Lord Baltimore was furious when he learned what she'd done, but the Assembly, Maryland's legislative governing body, came to her defense, assuring Lord Baltimore that she had preserved Maryland's safety. Emboldened, she went to the all-male assembly and asked for the right to vote as a property owner and as Lord Baltimore's attorney. The assembly denied her request on the grounds that she was a woman. So she and her sister moved to Virginia, where she acquired a large tract of land and lived until her death in 1671. The American frontier, in folklore and legend, was a land of cowboys, wide open spaces, and high noon gunfights. While there was a measure of truth to the legends, there were also new opportunities for women, because often there were not enough men to be able to do the necessary work. Susanna Wright, born in England in 1697, was a Quaker woman on the Pennsylvania frontier, and the most literate and educated of her neighbors. She therefore wrote wills, deeds, indentures, and other contracts. She served as an arbiter in property disputes and joined Benjamin Franklin in speaking out against attacks on Native Americans. In the 19th century, women found it easier to become lawyers in states closer to the frontier, where the establishment was a little less established and the professions less regulated. Arabelle Mansfield, in Iowa in 1869, was the first woman admitted to the bar. The Iowa Code stated that the bar exam was limited to any white male person, but she was permitted in nonetheless. Back east, that same year, Lema Barkaloo was denied admission to Columbia Law School in New York. The administrator said he would not be a part of degrading women to the practice of law. So she moved west to St. Louis, Missouri, and was admitted to law school at Washington University, where she became the nation's first female law student. She quit law school after a year, passed the Missouri bar, and began practicing in 1870, just months before her death of typhoid fever at approximately the age of 22. One obituary said she died of mental fatigue. In 1869, 39-year-old Belva Ann Bennett Lockwood, a teacher and founder of one of the first women's suffrage groups, applied to 3 law schools: Columbia College, now George Washington University, Howard University, and Georgetown. She was denied on the grounds that her presence would distract the male students. In 1870, she drafted a bill that made it illegal to pay women less than men in civil service positions. In 1872, her bill was passed. In 1871, she was at last admitted to a law school as one of 15 women entering the first-year class of National University School of Law, which is now part of George Washington University. She finished her coursework, but none of the women were allowed to go through graduation or receive diplomas. She wrote to President Grant and eventually received her diploma, but she was the only woman in her class to do so. In 1906, she became the first woman to argue before the Supreme Court. She represented the Cherokee Nation in a lawsuit alleging that the U.S. government violated a treaty. She won, securing a judgment of $5 million for the Cherokee Nation. Jane Foster was a student at Cornell Law School from 1915 to 1918. She excelled at her studies, served as editor of the Law Review, and was elected to Ordre de Coeur, an honor society for outstanding law school graduates. After graduation, no firm would hire her. With the help of one of her professors, she finally found work, not as a lawyer, but as a legal assistant. She worked as a legal assistant from 1918 until 1929, watching as one man after another advanced to partner. With strong recommendations from Cornell law professors and her employer, she tried again to find work as a lawyer, but never succeeded. The Wall Street firm of White and Case wrote to the law school's dean, telling him that White and Case steadfastly refused to take women on their legal staff and was certain they would continue to adhere to that policy. Unable to find work as a lawyer, Jane instead used her financial skills in the stock market. She purchased stock in companies such as the Computing Tabulating Recording Company, the company that was to become IBM. She amassed a fortune that allowed her to donate generously to the Cornell Law School. In the 1950s, while Ruth Bader Ginsburg was an undergraduate at Cornell, Jane returned to her hometown in Ohio and cared for her aging mother. She never practiced law. Before 1920, there was perhaps an excuse for excluding women from the practice of law. Without a voice in making laws, how could women enforce or interpret them? But the passage of the 19th Amendment, giving women the right to vote, did not open the courtroom or the law school doors to women. A 1922 Barnard College graduate recalled, "At the time I was ready to enter law school, women were looked upon as people who should not be in law schools. I wanted very much to go to Columbia, but I couldn't get in. I went over to see Harlan Stone, Dean Stone, who was later Chief Justice of the United States Supreme Court, and asked him to open the law school to women. He said no. I asked why. He said we don't because we don't, and that was final." One major firm in Houston prided itself on hiring women lawyers through the 1920s, but the women were given work as librarians or clerks and were never given real legal work. The Depression made the situation worse. Women lawyers who interviewed or asked for work at firms were asked how they could possibly be considered when so many men with families to support were out of work. Even though women had little chance of being hired as anything other than secretaries or librarians in law firms, women continued to go to law school, often excelling. A few lucky women did find legal work, but they never expected advancement. They certainly didn't expect to make partner. One major law firm, Sullivan and Cromwell, did in fact hire 5 women lawyers in the 1930s, but no woman made partner in the firm until 1982. Women went to law school in greater numbers during World War II because wartime enrollment for men was down. During the war and man shortage in the country, many women were able to find work, not only in the legal field, but in all fields that were typically dominated by men. But at the end of World War II, women were expected to return to the home and give their jobs to the returning veterans. In the 1950s, women were occasionally hired by the prestigious firms, but they were the exceptions, frequently hired as a token woman to show that the firm was progressive. Some firms said they didn't want to hire women for fear that the women would get married and have children and leave. Many simply believed that a woman's responsibility was in the home. Others were afraid women could not keep up the pace or would have emotional outbursts, resulting in bad relationships with courts. One female graduate of Harvard Law School in the 1950s offered other women a warning. "Beware of firms, especially looking to hire a woman lawyer. They want you for work they cannot get any man to do." People often asked Ruth Bader Ginsburg why she went to law school. Those asking the question were perhaps expecting an idealistic response, like the famous answer given by Oliver Hill, one of the NAACP lawyers who helped bring about school desegregation. Oliver Hill said, "I went to law school so I could go out and fight segregation." "I became a lawyer for personal, selfish reasons," Ruth said. "I thought I could do a lawyer's job better than any other. I have no talent in the arts, but I do write fairly well and analyze problems clearly.